Welcome to the Rise Network podcast show, a podcast dedicated to help you reach your dream lifestyle through investing in real estate. We're going to be sitting down with new, intermediate, and experienced investors to talk all about real estate and how it has changed their lives. If you're looking to scale your portfolio or even just get into real estate investing, you're in the right place. Make sure to tune in.
What's going on, everyone? Welcome to the Rise Real Estate Investing Podcast with your host, Mayu Taba and
Austin Ye.
What's going on, buddy?
No. Don't do this shit. You've been doing this for 2.5 years now, so I asked you, how's it going?
Good, man. But we were in Miami last weekend, and it was a little bit of a bender, and then came back and just trying to get by to the weekend, man. So,
Yo, have you had these hangover pills before? I've heard things about it. Have you tried it?
There's no way. If it
Listen,
was
but you never
actually
tried
legit, it's probably like having like a Gatorade. You know, like
Yeah.
it'll work
it's for sure. It's
moment.
probably just vitamins and electrolyte or something along those lines.
Yeah.
I'm gonna head to Mexico City next week from Wednesday to Sunday.
Just going for fun?
No. I guess like I wouldn't call it a bachelor. I guess somewhat of a bachelor.
Okay.
But really more so of a vacation, right?
Yeah.
So it's gonna be pretty fun. But I'm not looking forward to the hangovers because, dude, I can't function when I have a hangover.
This weekend was it showed me how old I am now. 31, bro. Can't do it like we were 27 and shit.
Basically, yeah. So, I mean, what have you been up to the past week? I mean, we did a pod with Jazz. Maybe we should talk about that.
Yeah, fuck, that was a good podcast. Eh? Like I walked out of it just feeling good. I think because we do our podcast on Zoom and stuff like that. I think the in-person conversations are something that it's a different caliber of conversation. I think like it's more natural. It's you can go into like a bunch of random tangents and like come back out completely like unscathed, and it feels more like a natural conversation than on Zoom where I'm looking to see is Austin going to talk now or is he not, right?
Right.
We'll take some things away from that conversation because I think we could probably start to do at least like a couple episodes in person and kind of get that kind of conversation for the right caliber of like guests and stuff like that.
Right.
But we'll kind of see. We'll try to implement that in the next week or two, right? Worst case, we just get a random studio.
For those who don't know, basically, like Jazz, he's either co-founder or maybe sole owner. I believe it's a co-owner of Rec Canada, one of the largest real estate brokerages, either in the province or maybe in the entire country. He has like over 60 agents under him. He had Mayu and Dai on for a live podcast. He live streamed it, and it was pretty cool. We went in there, no expectations, and then he came out with like a booklet of news articles, like which one do you want to talk about?
Yeah.
And then we just like are shooting the shit. We're reading the article live. We're giving our thoughts on it. Questions were completely organic. Have you guys seen like Theo Vaughn's podcast where they're just like shooting the shit
Patrick
and they're like,
David, Joe Rogan, they all do it kind of like the same way, right?
Jamie, pull it up. We need to get ourselves to Jamie. You pull that shit up. Anything else on the real estate end though?
Let's see. Unemployment dropped, right? It fell 0.1% in January. Yeah, I'm like I don't know if we're gonna have these cuts in the first half of the year like everyone anticipated. The data,
they're getting pushed back again and again.
Yeah. The data is not supporting it. Yeah, the data is not supporting it, and I can't wait until more people realize it because we need this freaking housing market to chill the fuck out.
The other thing is that I mean, like housing is the biggest sort of. We're talking about also U.S. inflation, right? It missed expectations. Which is not a good thing.
It was higher than expected, right?
Yeah, exactly.
Yeah.
It's higher than it was expected to grow, but it even not beat. It was worse off than analyst expectations by 10 basis points. Housing seems to be the issue in Canada, driving inflation. And it was funny. Someone asked Tiff Macklem, why aren't you cutting down rates to help with like housing supply, which is somewhat true. But Tiff was like, look, we cut down rates. It doesn't help with the housing market. We increase rates. It doesn't help with the housing market. Like, we can't influence housing, which is somewhat true. There's a shit situation.
He basically said it's not his problem, which is true, right? Like, housing is not the economy. It's one part of the economy, right? But it's not a standalone, like, it's not the entire economy. We just feel it the most in housing, right? But the economy as a whole is actually doing decent, you know? Like, unemployment going down is pretty big. That too in January. Like January's, I guess. Okay.
But wait. Let's preface by saying a lot of the jobs were part-time, right?
Okay. Really? I didn't even get a chance to dig into it.
Yeah, a lot of it is part-time jobs. And I'm trying to remember, it's either less full-time or not, or very little increase in full-time.
But keep in mind, like population growth was also like positive, right? Like we had something like a 0.4% population growth. So unemployment even just keep it up, like not really, like you would expect unemployment to be going up, right?
Right.
And so even just kind of staying where it is, that's still positive news, right? The point is like the data is just not supporting like an actual negative outlook, which is what you need to be able to justify rate cuts, right?
Yes and no. I mean, yeah, it depends.
Yeah,
I mean, there's so many indicators, right? Like GDP per capita is kind of gross, and it's not going to get any better.
It's still not
No,
negative.
per capita is negative.
Oh, per capita.
Per capita is negative,
Yeah.
right? Yeah. But anyways, like, we're not economists here. Right? But no, I think the point we're trying to get across is people were celebrating way too soon.
Yeah.
You know, and it seems like every piece of news and we talk about this in Jazz's podcast. Actually, maybe we should save it for people to listen to that one.
Basically, the news is a lagged indicator, right? So by the time the news starts talking about, cuts might not be happening, like it should be well known based on the actual data on the ground like a month ago, right? But yeah, definitely check out Jazz's episode. What else is going on? I'm starting to get lazy to make offers now because of the shit that we've been seeing in the market. And I'm like, you know what? I'll make a bully offer and then I'm out. I'm not trying to be a 1 of 20 on offer date, right? So that's been my stance recently, but we'll see. I'm also not crazy to like rush into like making an offer. Like I think there'll be other buying opportunities in the next couple of years, right? I don't think we're going into this period of massive growth, right? It's more so a period of buy when there's less competition, stay out of the market when there's crazy competition, right?
I think we have a good sense. There's going to be a point in time, probably, maybe, possibly even this year, where things slow down drastically again if things don't go to, as anticipated. Yeah, I shared an article. I don't know if you saw it. Oh, I just shared it this morning, so maybe not. But there was a story about the tenant, man, who fucking there was a case of a tenant not paying a landlord.
Okay.
It went to the Ontario Superior Court of Justice. Like, it went through the LTB onto the Superior Court.
Okay.
It was like $90K in unpaid rent, and like the LTB could only do $35K. It's fuck. It's crazy, man. The system is so broken.
You gonna tell us the verdict or?
Yeah. So, dude, it's professional tenant. This is like biggest nightmare situation. Basically, in a nutshell, the tenant stopped paying rent. They went to the LTB. Maximum was $35K.
Yeah.
And then there was an eviction. The tenant motioned for, I guess, like a pause on the eviction, right? And then postponement because they wanted to fight it. And then the tenant continued to not pay rent, so bought themselves more time. And then now the damages were way over $35K. And so the landlord was like, fuck it, I'm pulling this case out of the LTB. So the landlord withdrew it because the landlord's like, if I go to the LTB, I'm only going to get $35K. I'm taking this all the way as high as I can, right? Yeah. And then what the tenant said was, the tenant's like, oh, he never withdrew it properly. So we're still supposed to go to the LTB, right? And then so the tenant was trying to buy themselves more time, plus also limit the damages, but the LTB was like, nah, he did it properly. So then he took it to the court, right? And then the tenant was arguing to the court that you have no jurisdiction to be doing anything with this landlord-tenant board stuff, right? Like, it's out of your control. And said that also this landlord didn't follow the right processes and notices, LTB, et cetera. And the court was basically like, you are fucking out of your mind. So you're paying all $90,000 back, plus it was another about $20,000 in damages. But that's because the guy had to pay 16 legal fees, et cetera.
16 in legal for Supreme was not bad. Yeah. That's crazy though. The tenant's probably still like clean bankruptcy, I bet.
It was in Toronto though. It was like a $3 million house, a $2 million house. So.
All right, that's a good transition for today's episode. Today we've got Ryan Carson. He's one of the go-to lawyers in the real estate industry for a lot of us. They do residential, commercial real estate investing. But in this episode, we covered a lot of like the real estate legal issues. What do real estate lawyers actually do? What happens when someone fails to close, both as a seller and as a buyer? We've definitely seen both sides of that. Legal remedies, what's actually like a practical solution? What's the power of sale process? I'm sure anyone that's ever been a lender or debating being a lender has kind of considered that, right? And then really what kind of factors either power of sale versus foreclosure. So we really deep dive into the legalities behind the real estate law section that honestly, a lot of us as investors, we don't really cover. So hope you guys enjoyed this episode. And if you do, make sure you guys drop a 5-star review on Spotify, share this with a friend, jump onto YouTube and subscribe to the Rise Network YouTube page and drop a like on there because we're trying to start up the YouTube page a little bit.
Just a heads up before we get started, this podcast is all about providing you information, not financial or legal advice. So if you need the real deal for your situation, hit up a professional. We can't promise you our information is always up to date or accurate, and we're not responsible for any investment decisions you make based on it. Markets change, information change, you know the drill. Anyways, thank you for hanging out with us responsibly. Let's jump right on in.
Hello, everyone. We are joined with our very special guest and legal expert, Ryan Carson from Carson Law. How's it going, Ryan?
It's going great. Thanks for having me.
Awesome, Ryan. Thanks for joining us today. Just kind of start off with a level set here. What is a real estate lawyer? What do you guys do? Give us kind of your background. Just give us the rundown.
Yeah, sure. I mean, obviously it's a pretty broad question. I think just in a short statement, the real estate lawyer is sort of the closer, the professional that helps close the transaction, whether it's a sale, purchase, refinance, a private lend. We're usually the professional who's at the end of the processing line, if you will, to help make sure we've confirmed and captured all like the terms up to that point between the various parties to make sure the process is completed on those terms, and then also just troubleshoot potentially any problems that may arise either up to that point or they may be a new issue that comes up. But we're sort of like a closer. If you're a sports person, we're kind of like the guy who goes in to save the baseball game type of thing. But we're usually that professional to help finish off and coordinate and complete the transaction when you're talking about real estate matters.
Awesome. Yeah, I think the real estate, the law side, it doesn't get as much attention just because it might not be like the sexy deal making or whatever kind of that people see publicly on like social media and stuff like that. But I think myself and Austin have been, on the various sides of multiple transactions, lenders, borrowers, sellers, buyers, and we've kind of understood the significance of it. So kind of just jumping into things, I do want to kind of understand one of the biggest things that we're seeing in the real estate side today is a failure to close on the buyer side, right? What are you guys seeing within your practice? I guess before we jump into that side, what do you guys see as the biggest issue in today's world? Is it like private lenders foreclosing, or is it like defaults?
Yeah, I guess you kind of see like two different categories of buyers in that case. Like you've got your real estate investor buyer, which is obviously a bit different than just personal use buying, right? Fortunately, I would say most of the deals in both categories, at least like with our practice, with our clients and so forth, we've been pretty fortunate. I don't think we've seen a significant high content of deals not closing. But historically speaking, prior to the change in interest rates going up, and I guess the economy being a bit in flux right now, really, we probably saw, less than 1%, if any, deals not closing, right? Certainly not because of, financial issues or qualifications or that kind of thing on the buy side, right? So certainly there's been an increase. Fortunately for us, I would still say with our clients and our practice, it's still like a minority increase. Like, I don't even know if it would be 10% of the deals not closing. So we've been fortunate that way, whether it's our clients are, doing more of their homework and they're making sure they know they have the financing to go through, and or they've got a plan B in case plan A doesn't work for that. Fortunately, both on the personal buying transactions and on the real estate investor side, we haven't seen a lot of people not close. When they don't close, it's typically because of money. They're short, right? There's typically some shortage, or they don't qualify. Something's come up to disqualify them from what they had planned for. And so then it's just a question of, will the parties negotiate and provide an extension, right? To allow for a plan B if it's not in place to be, figured out, looked into, negotiated. Sometimes a plan B can be like VTB, vendor take back financing. Sometimes that's playing a bigger role than it's been in the past. But yeah, fortunately, we haven't seen too many deals not go through. But we have certainly seen more than we've seen historically, which is still to say there's been some.
Mm-hmm. Yeah, understood. That's a good point. That sort of lines up with the narrative of what we're hearing in the public, such that the non-closures of deals is a lot of it is due to financing appraisals running short on money. So again, it lines up with that. Sort of curious to hear your thoughts on, so you mentioned, I mean, one of the things that you guys do is you try to work on creative solutions, whether that be an extension, figuring out where to get the money from, vendor take back. When situations like that aren't necessarily able to pan out, what happens during a failure to close? Does it lead to immediate litigation? Can you negotiate a mutual release? Like what happens with the deposit? Can you sort of walk us through that process?
Yeah, I mean, certainly the process is anything but fast, right? Like, I mean, the only part that would be fast is if you could negotiate a mutual release. It would all depend on who you were representing, though, of course, right? If you were representing the party that, wasn't the breaching party, then likely you're not going to, we would not recommend a release, because we don't know what the damages are yet, right? Well, they haven't been crystallized, right? But, once you know what damages are, costs and losses and those sorts of things for the party that didn't breach the terms of the deal, then of course you could potentially deal with a mutual release. And usually it might be like they're forfeiting all or part of the deposit. And then the parties sign a release and nobody can sue each other because it's done. It's released, right? The deposit's been forfeited and or other amounts have been paid and it's done. It's over with. The release is certainly the most expeditious and most controlled process between the parties and potentially their lawyers or representatives. If you can't get a release because either it's not a good idea to from a legal standpoint, or you just can't get the parties to agree on the terms of a release, then there's always the possibility that the non-breaching party could bring a lawsuit and sue the breaching party, for their losses, costs, and damages, depending on obviously the court office and the region in which you're in like let's just say it's in the province of Ontario, that time frame, that timeline could vary, right? Like your ability to file and, start the court process and get an actual trial date if necessary in Toronto is going to be greatly different than it might be, say, in Halton. Right now, I think historically is probably seeing the longest process. That's not surprising probably to a lot of listeners and so forth on the basis that it is like the largest region, like from population size and so forth. That being said, though, it's not just the big cities that can be slower. It's sometimes the smaller rural areas, which I know are sometimes very popular areas for investors to try to buy in and to negotiate deals because of price point and opportunity and so forth. And so it is important to know that those can be slow too, or even sometimes slower, because even though you don't have higher volume, the volume is still high enough with such a low number of staff in those offices that it takes as longer than Toronto.
Can I ask you this then, with regards to when these, like, you obviously said it way more legally than me, but I'm just going to say, like, when people fail to close, right? And we're trying to determine damages in the case of a seller wants to sell, buyer's defaulted. A, how do you go about determining damages? And then B, at what point is the damages, like, monetarily worth going through, like, the litigation process of trying to recoup?
Yeah.
And sir, I think vice versa as well. I'm also interested in the opposite of my use, right?
Yeah, I was gonna ask that second, but
okay.
That's my thing.
Be efficient.
So, with like, let's say the buyer breached, so the buyer doesn't close on the deal, which is probably the most likely scenario. Normally it's not the seller that can't go through with it, although that can happen. But let's say the buyer can't do it. Let's say their financing fell apart. They couldn't get enough money. And so they had to just walk away from the deal. And they're saying, hey, keep my deposit. I'll sign a release forfeiting the deposit. Let's just be done with this. But then we're acting for the seller. We would say, okay, well, look, we're not saying you won't do that, but we need to figure out what are your losses, costs, and damages here, right? The only way to do that, like, fully is you need to relist the property and try to resell it, and let's see what you get. And so let's say they were supposed to buy it for $1 million and you relisted it and you diligently made all efforts to sell at fair market value in that current market, and it sold for $800. So you have a loss of sale price of 200K there. So right away, that's part of what you're suing for. You lost 200K, right?
Mm-hmm.
You had double, let's say, your cost with your realtor. Let's say you had double the cost with your lawyer because now it's like happened twice or whatever, right? And now you have your lawyer litigating, so you have those costs, right? So you'd put it all in a blender and you'd basically put that all into a claim, and those would be your costs, damages, and so forth that you would be suing the buyer for not following through with the terms of the agreement of purchase and sale. And in that case, like if the deposit was a large deposit, like let's say it actually was 300K deposit, right? Let's say it was a really healthy deposit. The realtor really did a great job negotiating, getting a higher deposit. Then advising to take the release makes sense because we know you pretty much covered all your costs, if not fully covered all your loss and costs. You just do the release, you take the deposit, everybody's done. But let's say it was like a really low deposit and it was only like 50K, right? Only 50K. Well, you still have a pretty healthy amount that you're out. And so there are definitely losses and costs there that you could seek the court to provide damage, like a damage reward on, right? But as we alluded to like a little earlier in this conversation, that process is not going to be quick, regardless of what court you go through, right? And some regions are going to be slower than others, right? Like you just don't put the claim in, they put a defense in, and then all of a sudden, you know, you're sitting at trial. You've got to go through other steps. You got to go through examinations. You've got to go through discoveries. All these things are a process that take time and obviously cost you money with your litigation lawyer, right?
Is there a threshold at which you find that it's like worthwhile to go through the litigation?
I think it's hard to say that because it's very subjective, right? Like as lawyers, I think if you're doing a good job with advising clients about the process of litigation, it's important that they understand it's long, it can be very stressful, and it can be costly. And everybody's always very fired up and typically, you know, excited or at least motivated to sue because they see the carrot there of like, oh, there's like 300,000 available here for me to go get. And they owe it to me, like they wronged me. So there's a lot of emotion and principle at the beginning. And so I think our job as lawyers is to try to be emotionally disconnected from it and say, hey, I get it. You're upset, Austin. I appreciate that. And you're not wrong that they owed you a duty to fulfill the terms of the contract. It didn't happen though. And now the problem is, yes, they owe you this money, but you know, you're going to spend X dollars chasing it. You're going to spend X hours of your life chasing it. It's going to take X months or maybe even years to chase this. If you want to do that, like knowing that and thinking about that and reflecting on that, if you want to go through the process, we will help you go through the process. But you really do need to take a reflection and say to yourself, yes, I'm buckling in and I'm doing this. Or, you know, you take a release and you take what's available and you have to reflect and accept that possible settlement, if you will, right? So there's really no way of answering your specific question of like, is there a threshold? Because everybody's subjective, right? Like some people would say no. Unless I want the full, like I want to write down to the full penny that they owe me. And that's fine. I'm going to buckle in and I'm going to go for it. And I've got the money to do it. So, and I've got the time and I'm fine. I'm comfortable. I'm going to do it. And then other people are, you know, much different than that. And they're going to say, geez, I know I'm taking a huge haircut here. They're going to give me the 50K deposit. I'm leaving like 250 plus on the table, but I don't have the stomach or the financials or just the time. Like they might be like, I'm comfortable and I have the money and I've got the stomach for it. I can focus that 50K, go to the next deal and just make more money doing that than I would focusing on a lawsuit. So it's very subjective, right? It's very subjective to the client, how they feel, what their personality is like, making sure The lawyer that's talking to them has really made them fully aware of what this journey is going to be like. And then they just have to make a decision. I would normally say, if it was me, personally, like, not even like using my lawyer hat here, like if I was the party that had to make a decision, like if I was the client, I'd try to normally settle myself, only because I'd look at it as, I could take this money. Yeah, it sucks that I could have got $1 million, but I got 800. I still made money on the deal. Like, that's another thing that helps. Like, if you still made money, you just didn't make as much money, then it's like, I'm going to move on. I'm going to get 50,000 in the settlement, and I'm going to go do something more productive with my time and that money. And I'm not going to have this stress and all this kind of stuff. Right. I feel like, practically speaking, for me, that's better. Right. But that's me. Right. If I lost money, like if that dropped from $1 million to 8 actually saw me lose on the deal, then that might change my view of it a little bit more, to be like, no, I've already lost money here. Like, $1 million was going to get me just a little bit of money, or a break even. Right. Now they pooched me by 200K. I'm going after them for that, because, they should have gone and got their financing. They should have got a plan B in place, and they didn't. So
does the seller normally recoup the legals?
Well, if you are the party bringing the court action, your lawyer will request costs. Like, they'll make a request, not only for the reimbursement of losses and all those sorts of things, but they'll make a request in the courts for their costs for legals to be covered. The judge has to make a decision based on all the evidence pleaded, whether they're going to get substantial or only partial.
Now I want to
you won't ever really get 100%. That's not really possible, but you could be reimbursed partially or substantially, are the terms.
Now I sort of want to shift towards the buyer side. I ask this because this is more common, I guess, in wholesale deals, more so than regular sort of transactions. You might have situations where a seller agrees to get into a contract, and maybe a week before they go MIA, right? Maybe they change their mind, so on and so forth, and they just ignore their phone calls. And you've already assigned the deal. Let's say there's like a $20,000 fee. What happens in situations like that?
So you're doing an assignment wholesale deal. You're the assignor, and
or let's just say, like, forget about the wholesale deal. Let's say if the seller just disappears, right? Because they're just like, oh, like the market is ripping, and so I don't want to sell it anymore. So I'm just going to stop responding to everyone. Much harder to prove damages there.
It really is harder. Like, if the seller breaches the deal, like whether it's they go MIA, like in the situation you described, either just in a straight sale or a wholesale, whether there's some reason they can't, like maybe there's a title search issue, right? Or something like that. And they can't, fix it or remedy it, and the buyer still wants to proceed. Yeah, that's a much harder situation. And I don't do our office's litigation. One of the other lawyers in the office does. I know we've looked into this over the last couple of years, because there have been like a few occasions where we've seen this in the last couple of years. My original thought always was, in talking with my litigation lawyer in the office, was, well, could we do what is called specific, like an order of the court for what is called specific performance of the contract, where you're basically getting a judge to say, we were ready to close, we tendered on them, showing that we could close, and they just didn't, for whatever reason. Legitimately or not, they just didn't close as sellers. So we want you to give us an order of the court that makes them go through with the deal. The problem with that, and I'd have to get this verified a bit more by my litigation lawyer, but the problem with that is the courts have put very narrow like parameters on like how you can actually get an order of specific performance. You have to basically show like that there's almost no other alternative property that you could just go buy elsewhere, right? Like, you'd have to show this is a completely unique acquisition. And so like, thus them not giving the order of specific performance would prejudice you in what's occurred with this botched deal, this defaulted deal. it's much harder to kind of create a remedy, if you will, for like a buyer who wants to go through with a deal that a seller's kind of defaulted on.
And even to show damages on the buyer's part, because like that happened to us on a deal before. And, you know, the market was down kind of like it is now, right? And then you end up buying something and then it's set to close, let's just say in like 4 months, right? And if the market,
Windsor one?
Yeah, that happened with our Windsor one. We bought it right in the middle of COVID, right? And then when the market started to rip, the seller was like, hey, look, I wasn't able to buy another house. And like, I'm just not going to like sell this house.
Yeah.
It was a pretty low purchase price for us. But the advice that we'd gotten at that time was you'd have to go out and like, you get an appraisal done at that time to kind of show this is the damages that were done, right? And obviously you have to be ready to close, right?
Mm-hmm.
And then you go get an appraisal done and you can kind of try and sue for the damages, or you'd have to go and buy like an identical house to show the market shift. But like no two houses are really the same, right? Like,
yeah, it's hard as a buyer to, I think, go after a defaulting seller. So I mean, practically speaking, like, your best course of action there, yeah, I mean, just trying to think if there's a way to like deal with it practically just with your negotiated terms. I mean, you can't really put a penalty clause in or something like that if they breach, right? I mean, you can sometimes do what is called like registering like certificates of pending litigation against the property. So it kind of like temporarily like binds up the property in case you wanted to bring a lawsuit. Just for breach of like terms, like, because what we talked about before was, you know, seeking a specific order of like performance, right? Which the courts, that's much harder, as you found in your example as well, to actually do, because you need to show that like unique ability, so to speak, right? But you could just say there's been a breach of the terms, and, you know, if you were an investor, like you could say that we had trades set up. Now like we sought to pay them certain like minimum fees because that was the deal with the trades. We already ordered a whole bunch of material. Like, so there could be other things, right? As real estate investors that you actually do have like quantifiable damages and costs on, like trades, supplies for renovations. If it was like a reno development type of thing, could even be like issues with like potentially set up tenancies, right? Like maybe like you've like prearranged in some capacity tenancies and so forth for the property, right? And now you have not only problems with the tenants because they thought they had a place to live, like, so you're dealing with tenant issues, but like you could quantify possibly and be able to show, you know, multi-residential property with like 10 units, each cash flowing us like $1,000 a month or something, or $500 a month, you know, over the course of the year. That's sizable, like as far as like cash flow revenue you've lost. Like, so there could be things you could quantify as a buyer possibly in trying to bring a lawsuit for breach of terms of the agreement of purchase and sale. But I think it's easier for the seller to bring a lawsuit and or negotiate like release terms and stuff when there's a breach. And thus that's why that's where that breach normally happens, is the buyer couldn't close, right? Much harder for a buying party to probably bring something that's worth actually spending the time and the energy and the money negotiating settlement or actually litigating.
Yeah, no, that's a thank you for the detailed answer there. And look, one thing that actually another person has done before, I think it was another wholesaler, is that they got the property at a good price. Seller didn't want to close for whatever reason, so they just had an option there that first prevented them from selling the property, as you mentioned, but also that they would have the right to purchase the property at the same price at a future date.
Right.
But I guess it's just like the negotiation and creativity. But usually if a seller's not going to close, then they probably have something else.
Well, and that's an interesting point that you say, like maybe just to add to that, like that could, if you found that the reason the seller was kind of going MIA or saying they're not going to close, it's because, you know they could put it back out on them. Like they could put it on the market and get an extra 100K or something like that. Because you got such a sweet deal, or because the market changed so much. You could always potentially put it in there, like you said, Austin, that you get like a first shot at it, right? Or you get to renegotiate the purchase price back up to 100 or whatever, right? So maybe it like keeps the deal going. Everybody just agrees like, yep, we still need to make this a good deal for all parties. I'm still happy paying more money.
We want to get into private lending a little bit, but before we pivot into that, I want to just sort of round off this like contract sort of dispute discussion. Let's talk about things that we can do to prevent matters like this happening on an investor or a home buyer side. These are sort of common disputes that come up in our conditions or when we draft up contracts. What are some things like what are some common liabilities or issues that arise for either investors or buyers, and what are some things we can include in our contract to ensure that we're well protected?
Yeah. Well, I think on the buying side, like, I mean, with the market shifting and kind of becoming more of a balanced market again, I mean, maybe some areas are, seller markets or buyer markets, but I think overall it's fairly balanced again. Like you're able to like actually put terms into the agreement. It's not just like you got to outbid everybody. You got to go in firm offers, outbid everybody, right? So you can put in conditions. So, I mean, you've got to like if you're a buyer, you've got to load up your agreement with, financing condition for approval, inspection conditions of approval, various other due diligence conditions, depending on if it's like multi-res and commercial for like zoning, work orders. You might need to do environmental. Again, depends on like what the property is and how you intend to develop or use it. But I think simply put, you need to put conditions in, right? You need to, at the very least, have it so that your lawyer can review. Like if you're not going to put any condition in except one, like have it so that you can have legal review at least, right? And then hopefully, like, if you're working with us or another experienced real estate investor lawyer, at the end of the day, hopefully they'd at least say to you, well, you don't have any other conditions in here. Like, do you have your financing in place? Do you have a plan A? What if that goes to crap? What's your plan B? And I think that would be the next thing. Like if you're a buyer, you need to have a plan A and you need to have a plan B. You might even need a plan C, right? And you need to make sure those are all in place or you're confident in them prior to you pulling the condition, right? Because once you pull all the conditions, if you didn't do that and make sure you were really confident with your financing options, and then they all disappear on you, or you only had one and it disappears on you, like you've really pickled yourself, right? So now that the market again is a bit more balanced, I think it's really beneficial, and there's a great opportunity for buyers again to have more of a negotiation with what they're doing, but really protect yourself, do your due diligence, get your plan A's, B's, and C's in for financing opportunities. Expect for the worst to happen. Don't expect for it to go well, plan for it to go poorly, right? And so if you have a plan in place so that if it does go poorly, like it's not going to be a problem for you because you got a plan, you're ready to go, right? You're ready to go with the private lender that you didn't want to, but you have them, right? Or you're ready to go that they've indicated, yeah, they will give you that BTB for your down payment that you're short now, right? I think these sorts of things are the things that will help protect the buying like investor going forward with the way the market is, right? It's like plan for the worst, but then obviously hope that the best comes through, right? I mean, specific clauses, I think it's just really loading up conditions and so forth, like financing, inspections, but then actually do those things, right? Like the number of times I talked to clients and they had the conditions in there, they fulfill them or waive them, and then they didn't do anything. Like, it's just kind of like, okay, well, you got to look at yourself first here. You kind of blame yourself. You didn't do like an inspection. Or would have found that the basement's, like needs an entire new like waterproofing, and that's $20K or whatever, right? Or some foundational beams that are not to code, and now you got to spend money on that you didn't want to.
Yeah, and I think that's important. I think also though, aside from the buyer side, a good segment of our population, because I want to kind of pivot here to the private lending side. A lot of investors have looked at private lending as an alternative way to produce like true cash flow, right? Because the only thing you're getting is like straight interest payments and no liabilities. Now, in the last 2 years, the risk profile has changed drastically in private lending. But I'd love to hear, what do you guys see on the private lending side in terms of the type of loans, the issues that people are dealing with? Are foreclosures and power sales truly like significantly up? Like, what are you guys seeing on that side?
Yeah, I mean, I'm sure they are up. I don't know the stats on them or anything, but certainly, I mean, the news, whether it's like in a formal report or, it's informally being chatted about in like real estate circles and banking circles, certainly with the interest rate increase over the last 24 months, even like A banks, like the report unofficially is a lot of them are underwater. Right? Like a lot of people are technically in default of their mortgage terms, right? So I'm sure default notices, possible powers of sale, possible foreclosure proceedings are likely higher than if you compared them, to pre-interest rate increase, right? That all being said though, like fortunately we don't see too much in the way of that at the moment. And normally whatever we do kind of start down that path, fortunately, usually there's like some negotiations that are in place. And it's just, there's been a lag on the takeout financing happening. And so fortunately, it usually comes to be before you actually have to possess and sell properties and that kind of thing, which is good. Like, no, I don't think anybody wants to be a lender, or the banks don't want to be, they don't want to take properties, right? Like that's not their game. That's not their policy and so forth. And I think most private lenders are like that too. They're not trying to take properties from people.
Yeah. You might already have the answer to this, you might not, but are you seeing most of like the issues or the defaults on like renewal where the lenders don't want to renew, or is this like you're missing payments and you're falling behind and therefore now like you're looking at a power sale for?
Yeah, I'll probably say more. We seem like, and this is just us, we more so see us having to take notice or procedures when people are in default. So not as much like they were good, they paid all their payments, they just got to the end of the term, and it's like, hey, well, thanks, but we don't want to renew, so how are you paying us out? We don't normally see it in the, like, usually if that crosses our desk, it's been like, because it's been months since renewal and there hasn't been enough progress for the lender's liking, and they're like, we need to put a bee in the bonnet here and make this borrower realize they got to do something, or okay, we don't want to, but we'll take the property.
We're throwing the word power sale and foreclosure loosely. They're two different processes.
That's right.
Which one is, can you explain briefly what each one is and which one's more common in Ontario, and why is it more common in Ontario?
Yeah, I mean, so there are two processes. One is statute based under the Mortgages Act. That's the power of sale. And the other one is foreclosures, which is more through like the civil procedure process. They're both available to a lender, a registered mortgage lender, to take action when there's been default, right? They both take a long time. I won't kid you. They both take a while. Like no one's losing their place in 20 days, right? That kind of thing. Foreclosure is, I would say, substantially longer than power of sale. And thus, most banks, at least in Ontario, probably in the country of Canada, prefer power of sale for two reasons. One, of the two processes, it's procedurally quicker, like a resolution can happen quicker. And two, power of sale under the Mortgages Act is not necessarily granting you home ownership. Like you don't take over ownership of the property. You take over the ability to possess it, to then sell it, right? And that's what the banks want. Like they're not interested in owning your house, or at least that's not been historically the Canadian bank's policy, and process, right? Obviously, people, if you did a lot of stuff in the US and you read a lot about historical stuff in the US, like that's a bit different because their banking system's different. The banks took a different approach in the US, right? So this is really Ontario and potentially Canadian based mostly, right? So power of sale, quicker of the two, and you're getting an order of the court to possess it, to sell it. Mm-hmm. Foreclosure, you're actually getting an order from the court and you take over the ownership. So you actually own the house. The difference being when you become the owner of it, you not only get all the perks of being the owner, but you take over all the liabilities as well. So that's another reason why, like, the bank's like, why would I take over the property just to be subject to my own mortgage, right?
When would someone go for a foreclosure over a power sale?
I guess if you felt like there was a huge opportunity to, even after you had to take over the mortgages on the property, like, for example, let's say I'm the lender, you're the defaulted owner, I go foreclosure, and I actually get the order to foreclose. So now I'm the owner of your property. And let's say Austin had the mortgage against the property, right? Or sorry, no, it'd have to be me. So I had the mortgage on the property, right? But Austin had a second mortgage, let's say. So our combined mortgages now, I've got to satisfy and deal with them, right? And so the question is, in me taking over that property's ownership, is there still substantial equity even after I pay Austin? Right? There's a possibility to have equity. People might look at the foreclosure as being more attractive to them, because now, even after they got rid of all the debts and they paid off all the mortgages that are against the property, all the liens, whatever is against the property, tax arrears, the whole shebang, I'm still got a property that's more valuable to me that I can make more money on, right? So whereas you take that same example, but you go power of sale because the numbers are super tight. Like, let's say Austin's mortgage is entirely underwater because, like, I'm even going to take a haircut. Like, I'm barely going to get my full amount of money on a sale at fair market value because the price has dropped in the market. I'm going to do power of sale and not foreclosure because I only have to, as the first mortgage lender, satisfy that, like, wherever I'm at and above. So if I'm first, that's why everybody wants to be first mortgage lender. You don't have to worry about everybody that falls below. Like, Austin can sue you still because you owe him money, but Austin can't use the property as security. He can't leverage the property anymore because he's a second mortgage on the property.
Right. Like, Austin personally, but like, he's not going to be able to get the proceeds from the property. And then it's a question of, is litigation actually worth it? Okay.
Correct.
Isn't it also, from my understanding, correct me if I'm wrong, Ryan, like, to your point, if it goes through a foreclosure and there's proceeds, you get to keep it. In power of sales, those additional proceeds go back to the owner of the property. So if you have a lot of equity, it's like, I mean, it's a nasty, nasty thing to do, right? Like, don't get me wrong. It's not like a really fair thing to do, but you keep all of their upside. Whereas in foreclosure, they still get their upside after paying back all the lenders.
Just to make sure we're clear, foreclosure, because the lender who has now become the owner, but foreclosure, they have to take care of all the liabilities. But if there's equity and upside, they keep it.
Right.
Property homeowner will get nothing. The power of sale, though, as you said, if there is money left over after everything's paid, then the homeowner who lost their home would get whatever that proceed is.
It probably makes sense in like a fix and flip or like a land assembly where like you just got to do a little bit more work and you can like drastically increase the value to like increase the likelihood that everyone gets paid out a little bit more, right? That's kind of interesting. So I guess from a buyer's perspective, okay, we're frequently looking at power of sale properties, especially more relevant in today's world. We all have data or not all of us, but you know, it's very easily accessible data as to like what mortgages are registered on the property, first, second, third, whatever beyond that, right? So as a rule, like if we were to look up these properties and just see how much is a first mortgage and just offer a little bit more than that, like what is like, is that good? Like, is that kind of just all we have to do? Just, hey, what's the first mortgage on this power of sale? Offer a little bit more than that if we want to, and then they would accept the deal.
It has to be what, like, the market, like what would be deemed fair market value, right? So like if the mortgage on the property, you know, is $500,000 and that's approximately the outstanding balance. And the reason it's in a power of sale is because they missed their payments, right? The people that were the borrowers lost their jobs, right? Mm-hmm. And so, but the property's worth $1 million. And that's like being conservative. Like, let's say that's on the low end. You wouldn't just be able to turn around and say, hey, I'll give you $550. Because the problem for that lender trying to sell under the power of sale is anybody who falls like below them or any other creditor of the borrower could file an action to say that was improvident. They would say that that wasn't as per fair market value, because conservatively, fair market value is at least $1 million, right? So you can't just like undercut to get a good deal to cut out other creditors. I mean, it's on the other creditors to bring the action to say that this was improvident. This wasn't per market parameters, right? And they would have to prove why it wasn't per market parameters and that kind of thing, right? But you're playing a bit of a cat and mouse game there that you would probably lose if it was easily like provable, or you could demonstrate it easily in court that like everything on this street's going for $1 million. We offer them $550. They took it because they just wanted to offload it to get like their mortgage paid. And we're a creditor and we're pooched now because they only took $550. So it'd likely be like a second mortgagee, or it could be a property tax municipality or somebody like that that's going to bring an action to say, you accepting this deal and selling at $550 when we know it can go for at least $1 million is improvident. You're basically just undercutting everybody. You can't do that. They seek an order of the court to set that aside.
Like there's a property on the market that's been listed for like $1 million, let's say. I think real estate, I guess it's not even let's say, but the first position lender sitting at about $850. That's like what we can see on like Purview. And then there's the second for like another $290 and a third for like another $150 after that, right? But they've been sitting for like 4 months now, right? Just kind of sitting there on the market. So it's like, what is really market value? Like, is it really like?
Yeah, I mean, that's obviously more of a like, that's a much closer like draw than what I gave in my example. And obviously I did that on purpose, obviously, to kind of illustrate the, how the drastic nature that it probably would need to be. Right. Like the person that would claim that this is not like an above board transaction, like you've undercut the true value in the market just to try to pay off this mortgage, because you've got $1 million possible price and they've got a mortgage of $850, but then they have these other mortgages and liens against the property at like pretty substantial numbers that basically are exceeding $1 million. And because it's sat for well over like 4 months, like that would be a much harder, I think, task of somebody proving, your offer and them accepting your offer of like $850, $900 is not legit. Like, a difference of like $100K when you start factoring and plugging in what we just talked about there is going to be harder for somebody to overcome than the example I gave, which is like, yeah, there was only a $500K mortgage to pay out. We offered $550, but it could easily go for probably $1 million, right? But meanwhile, you've got these other mortgages or registered lien holders against the property that they're left in the dust now, right? So because they fall in, like they fall below the priority of the mortgagee who's done power of sale. So yeah, it's there's not a clear, like, it's all on the facts. It's all going to be like case by case, fact driven. It's going to be very specific to the property type and the like where it's located. What are the comps doing? 4 months on the market right now, like, is obviously, longer, but I don't think it's like to say like that's unusual in today's world because things have slowed down. Like most things are like 60, 90-day lists at least, right? So hard to say, but like in your example, like you said, the last comp being $1 million, but it's, it's getting close to sitting for half a year, first mortgage at $850, who's the one who initiated the power of sale, you want to offer like $890, I mean, or $900 or whatever, and they accept. I mean, that would be challenging, I think, for somebody to say that this is not legit.
We're digging down into this pretty deep, but I have another question in regards to this. So let's say that obviously, from my understanding with power of sales, the redemption period is up until the day before closing or the day of closing. So at any time, the seller can pay, even if the property has sold, if the owner is able to make the entire mortgage payment, that transaction is canceled and the buyer's out of their own pocket for legal expenses, so on and so forth, right? Because they were able to pay everything back and all the obligations within that redemption period.
Yeah, you're like, that's a little bit more in my litigators like purview line, but yes, there is a, I don't know if that's exactly correct. Let's presume it is for the most part. I know that you basically as a borrower have a fairly significant time period in which to like bring it into good standing. Yeah, even though actions have been started and or maybe even like it's gotten like quite a long way down the process. Yes, there is a redemption period that's fairly robust. The court wants the person to keep their place.
My question is this, like, and it's not going to be a common situation, but I'm asking this because it's a situation I've heard pretty recently in the wholesaling sort of, we're working on something. Basically, long story short, it's a power of sale. Power of sale. It has sold, right? The seller's lawyer has advised they still have time for the redemption, right? So that transaction can still technically cancel, although it has been sold. That being said, what if the homeowner themselves, the seller, wants to sell it cheaper to someone else, right? But it's enough to cover all of the lenders. They would be obviously taking a little bit less equity, but they also wouldn't be paying realtor fees, so on and so forth, right? Is that an issue per se? Because it's the seller's choice to sell it cheaper.
Yeah, and so I think it would be, because at that point, I mean, you'd have to do some case law. I don't know.
Sure.
It's a very interesting situation. But I would think a couple things that pop out to me there is, I don't even necessarily know what authority the seller has to sell anymore, because there's been an order and there's been a registration of the power of sale on the property, right? So, I mean, that would be like interesting. Even if they could do that, like enter into a separate standalone sale agreement, I think that the problem would be you'd have a conflict with the fact that there's already this other valid and legitimate buyer out there, right? That like through the process. So it'd be very interesting to see what the case law says there. Again, I don't know, without there being probably a little bit more digging there, but that would be interesting. I mean, the best advice I could give there is, make sure the parties that are involved definitely have lawyers working with them, and definitely that the lawyers have done their due diligence checking the recent case law on how that's been interpreted, because that could be a really mucky situation.
Yeah, no, Ryan, I think this is an awesome episode. We just want to be cognizant of your time. We've been going for a full hour here. For anyone that can't afford Ryan's early read, just started podcasting. Send a good invite, but Ryan, for anyone that is getting started in real estate investing in today's world, what's kind of like one piece of advice that you'd probably want to leave them with today?
I mean, I always like saying to people, like, make sure you have a good power team, being like, make sure you've got good professionals working with you. So have like a realtor who's or somebody who's negotiating the deals for you that's experienced in what you're trying to accomplish. So, whether it's buying properties to like rezone and convert, or buying to flip, or buying land to develop, or just buying like single family rentals to rent long term, like make sure you're working with somebody who has true experience in what you want to try to do. That's going to obviously help you a lot to make sure you're getting, good agreements drafted, hopefully, and good terms negotiated, that sort of thing. Make sure you've got a really good mortgage broker as well. Similarly, like they have a history and an experience of doing what you're trying to do with your investments. Have a lawyer similarly that at least is a real estate lawyer, like a devoted majority of their practice is real estate. It's even better if they're an investor as well, because I think they can appreciate and understand a little bit more of what real estate investor clients are trying to do than just a real estate lawyer. But definitely make sure they do real estate, like not just as an aside. Like I see a lot of clients come to me saying, oh, I don't feel like I got the greatest advice. Can I get a second opinion? And then, you find out the lawyer, 90% of their practice is family law. They do a little real estate on the side because it helps, pay bills and stuff like that. Right. So really get a good team in place with like the realtor, your mortgage agent or broker, your lawyer, insurance rep, because insurance is getting harder and more complicated. Right. So I think it used to be kind of the thing that everybody just kind of would be like, oh yeah, I'll get the insurance, I'll take care of it. But if you're a real estate investor, depending on the complexity of what you're trying to do, insurance could actually be something that ends up being a problem if you know, like if you don't have it in place, right? So having a good insurance rep and then having a good coach, right? We all need help. We all need people to bounce ideas off. You know, like you guys are probably great mentors or coaches for people to have, in the sense of you've been doing a lot of your own deals. You've learned a lot of your own lessons, right? It's trial by error a bit out there. And so experience is invaluable. So having a good mentor or coach with those other professionals, I would say, is the best thing that you could do if you're starting out and you really want to be successful in real estate.
Awesome. Yeah. And I think, Ryan, one thing that we didn't get a chance to talk too much about was your practice as a whole. But the second question for you is kind of, where do you see your practice growing out in the next 2 to 3 years from now?
Yeah, like, so my firm, the areas that I work on in my firm are real estate, which is kind of a whole breadth of things. But you know, anything real estate, I've pretty much probably done it. So like a lot of real estate practice in my area. I do like corporate and business work as well, because it goes nicely with a lot of our clientele, especially the real estate investors. So I help them do like corporate structuring, JV, shareholder agreements, incorporation, corporate structure for like planning and tax purposes. And then I also like to tie into that like estate planning. So wills, powers of attorney, family trusts, because again, it's full circle for me, right? Like if I use the real estate client who's an investor as a just an avatar example, I can basically help them in all those areas. They need all that advice, right? So that's what I do at the firm. I'm also like an executor and trustee. That's kind of outside of what we're talking about here. And then I have a lawyer that does litigation, landlord-tenant issues, predominantly more so for the landlord. We don't do a lot of tenant stuff per se for obvious reasons, but we do landlord-tenant actions for the landlord. We have a lawyer who does estate litigation as well. We have a little bit of family with another lawyer in the firm, and we have a lawyer who does patents and trademarks. So that's basically what we do as a firm as a whole, and what I do specifically in the firm. Where I see the practice heading, we're not going to obviously shy away from transactional work. That's just that'll always be what a lawyer does. Like they work on, one like matters, boom, 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 boom. It's a very transactional type of business, whether it's real estate or litigation or what have you. But I see us really shifting our focus on giving a lot more holistic advisory advice and work with our clients. So taking our existing clients and future clients and really trying to stress upon them the benefits of being properly structured, set up, organized, so that you're maximizing truly all of your goals and efficiencies. I think a real estate investor is a great example for this, because when you look at what happened prior to all the interest rate hikes, it was the rush and the excitement of like, go, go, go. And it was so competitive. And so everybody was transactionally driven, right? Like buy, sell, whatever, right? Very much about the deal. Very little focus, I think, for even very experienced investors. Like I'm doing some work with different high-end investors that have, lots of doors, and like, they don't even have like all their corps are like, they're all disconnected. There's no parent company. There's no family trust. A lot of them don't even have a will or a corporate will. Like if they have a corporation, which they do, holding their real estate, you should have a corporate will at a minimum, right? So there's just a lot of planning that naturally has not been looked at, because it was go, 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 because you had to, because that was the market. And now that there's been this step back or this cooling a bit, I really think post-COVID, post-interest rate, or during interest rate and fluctuation here, it's really given us an organic moment to really shift to say, we really need to plan. You guys really need to plan, because you could take Austin Ye, and you could be like, Austin Ye's kind of transactionally driven. He's got some planning, but not to the full scope it could be. And you can take that same Austin Ye with his same number of, properties and everything like that, and just put them over here and just do a more thorough review and be like, okay, we could do this, 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 and this, Austin, for you. And guess what? You'll make more money. You'll save more money if something happens to you, right? Your estate will have more of a legacy and so forth, right? That's what we want to try to do for the clients. And I think that's where we're headed for 2024 and beyond, because I think everybody's seen the excitement of the high-paced, market. There's been a lot of people that have seen, unfortunately, a lot of fallout too. I don't know if some listeners have experienced it, but there's a lot of people that had really strong reputations, really big policies and portfolios that have seen some hard times, right?
Right. I think it's exactly what you said. I think a lot of us, we are focused on the growth of our portfolios and not really the operational side or the cost improvement, which even corporate wealth in the States, that's one part of that exact issue that we just talked about, right? But Ryan, totally appreciative of your time. Glad that we had you on the episode. For anyone that wants to get in touch with you, what's the best approach for them to get in touch with you?
They can check our website out for all our details, which is www.carsonlaw.ca, or they can just email me, which is ryan@carsonlaw.ca, and I'll get back to them that day for sure.
Perfect. Awesome. Thank you very much, Ryan. I appreciate having you on.
Absolutely. Thanks, guys. It's a real pleasure. Take care.